You are now listening to Comp Corner, brought to you by the law offices of Bradford and Barthel.
Welcome back to Comp Corner, your go-to podcast for practical insights and strategic guidance in the world of workers' compensation. I'm your host, Nasir F. Adil, and today's episode is a continuing education deep dive designed to give you real, actionable tools you can use right away. Joining me today is JP Torres, partner and managing attorney of our San Jose office and a returning guest to the show. If you caught his last appearance on episode number 3, you already know that JP brings sharp insight and real-world experience to the table. In this episode, we're breaking down one of the most important and often misunderstood areas of workers' compensation: settlements. From handling pro-per applicants to navigating cases without medical reports, we're getting into the strategy, the pitfalls, and the practical tips that can make or break your case. If you're looking to sharpen your approach, close cases more effectively, and avoid common mistakes, this is an episode you won't want to miss. Let's get into it. Today's episode applies for CE credit. In the show notes, you can find the link to the CE credit form or send an email to compcorner@bradfordbarthel.com for a link to the CE credit. Please email your Comp Corner questions to compcorner@bradfordbarthel.com. Our email is in the show notes. A huge Comp Corner welcome to Mr. JP Torres. How are you, JP?
Hello, great. How are you? How are you?
Doing well. As you know, I call you JPZ, so I'll try and call you JP, not JPZ, which I usually refer to you as. For our audience, Mr. JP Torres is a partner and managing attorney of our San Jose office. JP is also a returning guest on Comp Corner, as he was on episode number 3 last March, where we discussed defense strategies to combat permanent disability. JP, I'm excited to have you back on to discuss settlements. So, as far as settlements go, obviously, there's no one way to settle a case. The best case scenario, as you know, as well as our audience knows, the best case to settle is if you do not have a medical. That means you get to avoid having to pay for a medical, and you settle without any medical report whatsoever. JP, in your estimation, how many of your cases settle without any medical reports or minimal medical reporting?
Sure. So, first of all, glad to be back on the show. With respect to absolutely zero medical, honestly, it used to be quite rare, but I'm finding more and more that it's gone up. I'd say maybe like 5, definitely not 10, but about 5% or so, give or take. And the reason I feel that is because I've seen an uptick in a lot of pure psych claims for things that would normally be very fact specific, like a
Hmm.
hostile work environment. For example, I see a lot of those recently, and so what I usually ask my clients first of all is whether or not a hostile work environment
Mhm.
would give rise to any other type of claim or cause of action against the employer. Is that itself an injury, right? Because again, we're
Yeah,
in
yeah.
workers' comp. It has to be some kind of like medical or, a medical issue causing an injury. So in those situations, like we said, because there is a factual dispute that this environment, hostile work environment exists, you may not have any medicals whatsoever,
Right.
right?
Yeah.
To prove it. So in those situations, I would, or like you were saying earlier about minimal medicals, we've
Mhm.
all been there where the applicant is just frustrated with the system. They want out. So
Yeah.
they may not be MMI, or quite frankly, they may have just gone for a couple of sessions with the clinic and then they're done, right? They don't want to go back. So in those situations, yeah, you would have very bare bones medicals, and that again rare, but I do see it happening. Yes.
Fair. Yeah. And that's why the benefit of settling without any medical or minimal medicals are obvious. You get to avoid having to spend the treatment costs, right, that come with treatment, let alone an expensive medical legal. What goes into consideration? Hey, the parties want to buy out their respective piece, right? It takes two to tango, two to dance at the dance party of settlement. And also, you have to value exposure, right? Sometimes you don't always settle for 2, 3, 5, 10,000, the nominal amount. Sometimes it's, hey, the defendant may see the 104 weeks of TD kind of looming, right? So they're like, hey, if I can pay maybe 70, 80 cents on the dollar now, maybe I'll spend 50, $80,000 on a CNR. I know that's not nominal, but to avoid the 104 weeks of TD, that's easily $100,000, let alone PD, treatment, future medical, etc. One thing that we're a big fan of, and I know I'm a big fan of, is every deposition is an informal settlement conference, right? So the attorneys and the claims examiners who don't have attorneys reach out to the other side before a depo. Say, hey, we have a depo coming up next week. Relay settlement because JP, as you know, attorneys, as a former AA applicant attorney yourself, the attorneys prepare with their clients, meaning on the applicant side, for an hour preparing for the depo. So if during that 1 hour, not only are they coaching up their clients, but they can also discuss, hey, what's it going to take ballpark to get this thing settled? Sometimes they'll take a couple thousand and then you're a hero. You get to report back to your client and say, hey, we settled a case for nominal value. Guess what? No PQME, no PTP. We're good to go. So, yeah.
I definitely agree with that. At any time before the depo, it's always good to maybe give your opposing counsel a quick call or an email saying, "Hey, could you reserve some 5 minutes, just a little bit of time before we actually get on the depo?" Usually they're done by Zoom now, right?
Yeah.
Just so we can chat to see if you can talk to your client, see if there's anything that they're interested in now. I know that at least and where we practice here in Northern California, that's not as common as our colleagues in Southern California. But I still think it's worth it to talk settlement, right? Even if it's just for them to say no, no interest. That way you can relay that to the client, and they're not trying to figure out what's going on. If the guy's not interested, then they're not interested. We switch tracks as needed, right?
Yeah. And we had an ongoing thing. I think it was like 10 straight Friday afternoon depots in our Oakland office where every attorney who had a Friday afternoon depot ended up settling a case. Why? Because it's Friday afternoon. The applicants don't want to be there. The applicant attorney doesn't want to be there. So guess what? Nominal settlement galore. So very good wisdom. But I do agree. Look, I would say 5-10% of cases do settle that early. So let's not, oversell the idea here. But even if you don't settle, but if you get some kind of counter from AA where you go on the record, but you can kind of feel them out and say, look, they really want X amount instead of, nominal amount. You can later keep that in your back pocket for settlement purposes down the road and say, hey, this is kind of what they're looking at. So either way, by communicating that, you give your client the best position to succeed. Talk about exposure on a case. So let's move on. Let's talk about potential settlements based on a primary treating physician's report. So this is a case, of course, where you got a PTP and you're able to settle based on a PTP. What's your opinion on that overall settlement process to try and settle based on a treating physician, JP?
So honestly, for a treating physician report, you got your two different types, right? You got your non-MMI, just regular run-of-the-mill PR2 reports, and your PR4 where they provide some kind of impairment. I find that settling on a PR4 report, uh, pretty straightforward. The judges will accept that because there's impairment right there. Usually they give you everything you need. Some amount of whole person impairment, some requisite future medical, as well as a permanent work restrictions. If they're following the standard PR4 format, that should be enough for you to settle on.
Right.
But barring that, if you have a PR2, again, kind of harkening back to what I said about if the person is just done with the process and wants out, I think the PR2 is still useful for a judge to be able to see where the treatment is going, like that trajectory of that treatment. Hardly ever, you're going to see a bunch of physical therapy, acupuncture, and then all of a sudden you're going to get like a
Right.
lumbar fusion or something.
Disc fusion, right.
Right, exactly. Not really going to happen. So if the judge can see that we're looking at primarily conservative care, and the kind of the asks from the primary treating physician are all fairly, medications,
Yeah.
patches, TENS units, those kind of things where we see is not typically surgical, then I think you're going to get a little bit more traction in getting that approved without an order suspending, or an annoyed judge going, "What? How do you expect me to value this settlement?" Especially in our area here, Salinas, I know for sure, and I believe even Oakland, you do get judges questioning you,
Oh
right,
yeah.
on how are they supposed to value this case
Yeah.
with the minimal medicals. And so I think that's where your defense attorney will come in, and as long as they can explain and articulate, you know, the basis, you have a better shot.
No, I think you brought up a great point. I think judges need to know what their adequacy or what whether the settlement is adequate or not. And you can have an adequate settlement without a final report, right? But one practice tip that I always tell attorneys and I try to do is look, if you're settling a case based on a PR2 report where the applicant is not yet permanent and stationary and there's no PR4 report, then you can't just e-file a PR2 report that doesn't provide any impairment opinion and hope the judge will be like, let's sign off. The judge may sign off, but more often than not, you'll have a judge who issues an order suspending action. So the best way I recommend avoiding that is to write a letter to the judge. Say, Judge, look, we know we're settling based on a PR2 report. We know that. We know you know that. Here's how the parties reached our overall settlement amount. This is what we value exposure on. And as you pointed out, JP, you're basing that on diagnosis. You're basing that on a treatment plan. You're basing that on what's been spent to date, what the doctor recommends moving forward, whether they're back to work, right? Will the judge let you get out for a minimal amount? Probably not, especially if the applicant's proper. They're going to want to make sure the applicant's interests are fully accounted for and the defendant's not, trying to pull a fast one. But that doesn't mean that you can't settle on a PR2 report, but it does make it more difficult, right? Right, JP?
Right, I agree. I mean, especially if you're providing medical treatment, we assume that it is an accepted claim, right? And then even if it's pure conservative care, the assumption is you are still going to give care arguably for the rest of the person's life. So if it's an accepted claim, even with that kind of minimal conservative care, you're not going to get out of it for nominal settlement value. A judge is still going to say, how is this adequate to to pay for projected medical treatment, even if it's just one or two doctor visits a year, right?
Yeah.
Let's say just minimal checkups, maybe some over-the-counter medications. That still has value there, you
Sure.
know.
And I guess perspective is always king, right? We always think judges have the right to sign off on anything, which most of them do. But a lot of judges, once you kind of talk to them a little behind the scenes, they're like, "Look, the judges don't want to get appealed. They don't want to get in trouble by approving a settlement that turns out to be inadequate." So, understanding their position and understanding their perspective is really a part of the process as well. Now, on the flip side, let's say you do have an impairment report from the treating doctor, JP. Um, What's your opinions on settling it based on an impairment report from the PTP or a PR4 report?
Love it. If we can get it
Yeah, yeah.
done, all the better. The only thing is, as you said, context, right?
Mhm,
Who is
mhm.
that PR4 written by? Is it by an occupational clinic, or is it by
Right.
your, pain management PTP handpicked by the
Sure,
applicant attorney? So
sure.
context there matters, right? I love it sometimes when a client will go, well, JP, here's this PR4, 0% full duty, no restrictions. Well, okay, but
Yeah,
who wrote it, and is that really gonna um, is zero really something we can settle on, right? And sometimes
right.
the most defense favorite type reports with 0%, everything is like denied, is not one that we can readily settle on, right? There has
Yeah,
to be some kind of give and take there. But same thing with the with an applicant oriented pain management or chiropractic PTP, right? Uh,
sure,
We have to balance those two.
sure. And don't get me wrong, here on Comp Corner, we're a big proponent of the 0% PD report. We're not trying to say they should not exist. We like them, but sometimes, and I'd have to discuss with my clients sometimes the report is too good. right? If you have a shoulder tear, or if you have a doctor who admits the applicant needs a fusion, but they're finding, 1% PD, then it might be a little too good because sometimes that report may not be substantial medical evidence. As far as some of the hindrances that get in the way of settling based on a PR4 report sometimes can include on my end the applicant, if they're not represented, or even an AA, they just want to have the right to a panel physician. And that comes up, of course. And that's why cases don't settle on PR4 reports a lot of the time, is because sometimes they're like, you know what? It's a decent report, but guess what? One side will want their right to a panel instead of settling based on the jury. They have that right. That's why you can go to an AME, you can go to a panel. That's certainly a right within. So makes sense. Thank you, JP. Now, as far as the most likely scenario, we talked about the first two scenarios. Best case, you settle without a PT, without a report or a medical. Second scenario is you settle based on a PTP, either a PR2 report or an impairment PR4 report. But most of the time, as we see in the workers' compensation game, most cases probably will settle based on a medical legal report. So in one instance, you have where the applicant is not yet permanent and stationary. If that happens, then guess what? You need a reeval. That happens 90% of the time where someone is not permanent and stationary. I'd say estimate about 10% of the time you're able to settle a case where the applicant's not yet permanent and stationary. At that time, some of the same factors go into place, right? Hey, maybe the applicant wants out. Maybe there's enough of a diagnosis or treatment plan for the parties to kind of gauge what the overall exposure is, and that can help you get out of a case at an earlier stage, right? But the more common route is, hey, you're permanent stationary by the panel QME or AME, then you go that route. So, JP, once you get a permanent stationary report from the medical legal evaluator, okay, what's kind of the next framework that you like to do and kind of touch base with your clients upon?
Sure. So we could do a whole other podcast on QME reports, but
Right.
definitely the first thing I would do is I usually jump to the end, see if they're MMI, and assuming that they are, we look at what impairment was provided, and you kind of do, um, like for me, it's a believability or smell test, right? You look at the impairment. Does it seem to make sense with the known mechanism of injury and how the applicant was treating so far? Right? We've all seen there where you were expecting one type of rating, and then all of a sudden you get blown out of the water because there's all kinds of additional things in there that you weren't expecting, like gait issues. Or
Sure.
today I was at a hearing because the QME provided um, impairment on what he called regional impairment, which
Sheesh.
in my years of doing this, I've never seen any QME provide, regional impairment.
Because it doesn't
So
exist, because
it
there's no
doesn't
such
exist.
thing as regional impairment chiropractor X. It doesn't
So
exist.
exactly. So that's what we're talking about. If you look at the impairment provided, does it make sense? Right. And if it does, let's assume, for example, that the impairment makes sense. Then just rate it out like normal. But if it doesn't exist, or I'm sorry, if it doesn't make sense, then we have to kind of strategize. Is there a way to kind of informally uh, point this out to AA and go, okay, this doesn't make sense. How do we really need to extend discovery for another 6 months, 1 year, or can we get the report that we have and pump out a reasonable settlement based on this? Because most QMEs, they will already do the physical exam. You can do you see the measurements, right? You see the findings. So we've all have the AMA guides with us. We can kind of use that to provide what we feel is a reasonable impairment.
Sure. So one of the main things is, look, if once you get the permanent stationary report, let's say it's a reasonable report, we could have a separate podcast or multiple on what to do if you're not happy with the impairment, right? Which you get the PQME supplemental, take the cross-ex. Shameless plug, our firm has a permanent disability rating department, which can happily provide string ratings or full out rating analysis for your medical legal report. But what I like to do is, once I get that report, I get a PD, permanent disability string rating, done. Okay. Then, of course, along with that, you have to value out future medical care, right? Provide evaluation. When that happens, hey, client, let's touch base right away. Here's a PD. Here's what I estimate future medical to be. Along with that is whether they're on Medicare or not, right? If you need an MSA, and I'll happily shift that over to you in a second, JP. But once you find out PD, future medical valuation, which could include MSA, then guess what? You have the ding, 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 compromise and release range. So, JP, what's your opinions on MSA, that whole process, and getting that going?
Of course, it's going to be region specific. If you talk to your favorite MSA vendor, most will say that an MSA, Medicare set aside, is never necessary, right? The statutes don't mandate a Medicare set aside. We do it for as a part of our better business practice, better legal practice, because how does one ensure that Medicare's interests are adequately
Considered. Yeah.
considered, right?
Yeah.
How would we know? We would never know. So the best way to do that, of course, is to get that Medicare set aside prepared professionally and have it approved by CMS. They'll
Mhm.
review it. They'll say, and we've all been there. We see the number provided by the MSA vendor. CMS comes back and they slightly tweak it by adding some additional funds. Only one time in my career I've seen actually CMS reduce it. Only once. But most of the time they'll increase it. And then so if you, as long as you stick with that plan, great, right? No issue. But of course, there are different criteria on when CMS will review that that MSA. And the more recent changes, right, is that if you've got a denied case for whatever reason and you're going to
Yeah.
do a zero MSA, CMS no longer reviews that. So again, my best practices, I usually tell the client that they should reach out to an MSA vendor to weigh their options, because really they are the experts on whether this is the type of claim that may or may not benefit from that. And also, one thing I was going to say, or I forget, is that so regarding the regional differences, even though I did say that the Medicare set aside is not required by statute, some
Mhm.
judges still will require you to present it to them before they will approve that CNR. So even though it may not be technically necessary, if the judge is going to issue an order suspending because they want to see that MSA, then you have to couch in that scenario as well. And also, as a defense attorney, it's we need to explain, usually in a letter or in person in a walkthrough, why the CNR, I'm sorry, why the MSA was either looked at by CMS or not. Because, judges, it's like all of us, also lawyers, also workers' comp attorneys, but depending on when the last time the judge was actively practicing is either a defense attorney or applicant attorney, as we've seen with this new regulation, the requirements do change over time, right? So who would be the one most knowledgeable for that? Of course, the
Yeah.
Medicare set aside vendor, who is always submitting these things to CMS. So we need to get to make sure that we have that information from them, or at least have the client open a dialogue to see if it's in their best interest to get one done. And
Absolutely.
if they don't want to, then that's their right. But at least we saw the issue, we spotted the issue, and presented it to them for their decision. Right.
No, you're totally right. I think you brought up a great point about, foreseeing issues, right? That's how anyone in the defense game or applicant game, once you foresee issues, then you're able to hopefully resolve problems while they're small without having to deal with big problems. But look, if you're dealing with an applicant who's 70 years old, who's on Medicare, when you got the final impairment report, an MSA should not be a huge shock, right? So if you're properly getting the releases early, sending them over once they're permanent and stationary, you're really helping solve the discovery process, and you're saving money over the long run, right? You're not keeping a file open for several months on issues that you should have foreseen when you got the file initially, right? So if you see the need for MSA, start that early. That's the practice tip. You can save a lot of time. You can also gauge whether CMS approval is necessary or not. Thankfully, knock on wood, CMS approval has been much, much more reasonable than it was in the past. Sheesh. I remember a point, 10, 15 years ago where it took about 10, 12, 14 months to get CMS approval back. Thankfully, we're not in that range anywhere close to that right now. But shifting gears a little bit now. So one thing I'm a big proponent of is when you get that final report addressing impairment, then it's really a time to get together with your client. The defense attorney should get together with the claims and maybe even the employer to talk about exposure and settlement authority. Okay. So the practice tip here is once you talk about authority, talk about exposure, get your authority, really make an offer right then to applicant attorney, because when you make that offer, then you've started the timeline for shutting down discovery. If you have a good report, ideally you'd like to shut down discovery without having the other side, do additional discovery, which could include a PQME supplemental, a PQME depot, a rebuttal from the PTP. So once you make an offer, it has to be a reasonable offer in good faith in order to file the DOR. And after a reasonable amount of time, then you can file the DOR, close out discovery, and ding, 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 shut down a file. Right, JP? What are your thoughts about that whole process and really getting a claim towards the final settlement posture stage?
I do like that that method and that kind of fact pattern. The one thing that I would always recommend is uh, if you're not represented, get with your friendly neighborhood defense attorney, because it especially on the defense side, it's really tough for us to say that we're ready to go to trial, and then oops, there was some report that needed clarification or what have you. I found in my personal experience that the judges are more forgiving for the applicant if it's like oopsies, we actually there was one other extra issue, whether or not it be their DOR or not. But if those
Sure.
tables were reversed, it's much harder for us when we're saying that we're ready to go. So um, my only caveat on that plan is, yes, be sure that you are in fact ready to go. But if you are, yeah, definitely, I mean, shut it down. And if anything else, um, that MSC is a good spot to talk negotiations. It's only, at least in our area, there's only a handful of judges here who won't give you time to talk to opposing counsel, even at the hearing, right? I mean, some feel like all discussion should have taken place before in your meet and confer, but honestly, I think a few minutes or more at the actual hearing with some maybe feedback from the judge does a lot of good for a lot of cases, right?
Oh,
We've
yeah.
all been there where we talk to the judge and then the thing settles, right? So
And you brought up a good point. If anyone's been doing the defense side for a decent amount of time, you understand that the tie doesn't go to the defendant; it goes to the injured worker. Shoot, more than a tie goes to the injured worker. Is workers' compensation fair? Probably not. Right? Is anything really fair in the world, let alone law? No. It's called workers' comp for a reason. Literally, it's in the name, workers' comp. But that doesn't mean that we have to be on our heels and allow for discovery to take place while we're idly standing by, right? We should be the one who are on our toes with this whole process, right? But you can't be on your toes on the defense side as far as being aggressive with shutting down discovery, settling cases, if you're not initially getting those reports and contacting your clients right away, because you can't get to a DOR without first having settlement authority, without first having rated the report, without first having addressed future medical, MSA, et cetera. So practice tip here is when you get a report, whether it's any type of impairment report, address quickly, whether it's settlement or discovery, because if you don't move on discovery, then again, on a future podcast, we'll discuss all of the problems that can come about with not acting on a report that should have been addressed by a supplemental or a cross-ex. Because if due diligence isn't done, then guess what? You're pretty much going to get left in the dark.
Did you know there is an 8 in 10 chance that the whole person impairment found in your medical legal reports is inaccurate? As a result, benefits are often grossly overpaid, including unjustified life pensions. B&B's AMA Guides Analysis and Rating Department has reviewed tens of thousands of PTP, QME, and AME reports verifying these troubling statistics. The results confirm that 79% of reports misapply the guides to overvalue impairment, 2% undervalue impairment, and the tiny remainder is actually accurate. B&B's experts have decades of experience analyzing physician reports and outlining their shortcomings in applying the guides and legal theories such as Kite and Alvarez Guzman. Our services help prepare parties to cross-examine physicians and draft legal arguments to ensure that the benefits you deliver are correct.
JP, let's shift our attention to the actual drafting of a compromise and release, right? So, compromise and releases, they're 9 pages long, but oftentimes have addenda. One of the most important things I think that goes into a CNR is the body parts listed. Can you tell everyone, in your opinion, why the listing of body parts on page 3 of a compromise and release is so significant?
So the body parts listed on page 3 are the body parts you are resolving. In the body of the CNR itself, and in that little boilerplate area, the fine print, as you can call it, it specifically forbids settlements of body parts or parts and or conditions, right? Because it doesn't have to be a part; it could be a condition too. That's not expressly written in that area, right? So if you for CNRs especially, you always want to over add. If you look,
Oh,
if
yeah.
the applicant, again, as we talked about earlier with the primary treating physician reports, et cetera, the applicant may uh, mention other body parts that may not be explicitly pled in the claim, but could be related. Sometimes you'll see that in, for example, neck injuries, right?
Mm,
Neck injuries you'll see can be they'll say, oh, doctor, I've got these really splitting headaches, when it turns out that headache is really just referred pain from the neck. Or similarly to the shoulder, I recently had a case where the applicant was sure he had a shoulder injury, and even in that one, actually, they got a chiropractic QME, but even that QME was like, no, I don't see anything wrong with the
mm,
shoulder. This is actually referred pain from the neck. It's a neck injury. And then which made more sense, because when we got his non-industrial medical treatment, there was a history of neck pain, neck treatment, right? No shoulder treatment, but neck treatment. And then so it makes sense that the doctor was like, based on what I'm seeing in my physical exam,
mm.
this does not appear like a shoulder injury. And lo and behold, it wasn't. So we always want to make sure. So again, in that one, it's pled as a neck. Or I'm sorry, pled as a shoulder. But when we came down to CNR, you want to make sure neck is in there, because that was actually truly what the body part that was injured, not the shoulder. I mean, that's where you were feeling the pain, but the pain generator, where the actual injury came from, is the neck. So you want to make sure that's done.
Yeah.
So in CNRs, I think over include body parts.
Yeah.
And if applicant attorneys, sometimes they can be resistant, because they'll say,
Mm,
well, that's not included in this claim. Then as long as you can point out to where in the reports why it's relevant, say, well, your client mentioned this on all these
mm,
reports here,
mhm.
so clearly this CNR is for everything, right? We're not piecemealing this case. So if you disagree, applicant attorney, then have you done any discovery? Have you added body parts? But I wouldn't let it go, right?
Right, right.
If those body parts have been mentioned by the PTP or to the PTP, get them in the CNR resolve.
No, great practice tips. I think one practice tip, to your point, is I always try and include body parts that are on the claim form, that are on the employer's report of occupational injury or illness, that are subjectively complained about, that have impairment provided for, and of course, what's in EAMS, right? If it's pled, it's got to be on there. Another practice tip to keep in mind is you're only settling a case that is involved with that injury. What do I mean by that? You're not settling out with the CNR, you're not necessarily settling out every single injury the applicant has ever had in their lifetime, right? From the date of birth until current. That's something that can get confusing. So oftentimes we're out there, we have an employee who's been there with the employer for, 10, 20 years, and they may only have one ADJ, but they have other medical only claims that are out there, right? So when that happens, you can still add in other injuries onto a compromise and release, but you should really get an ADJ number assigned, list that on the compromise and release, because you can't just surprise anyone with extra claims on a CNR. The applicant attorney has to be on board with you adding in probably a little consideration for those extra claims onto a CNR, but get an ADJ number at time of filing. That way, you're truly resolving every claim, not just you thinking you're resolving every claim. Meanwhile, you're not settling what you think you're putting your contract in place for. Now, JP, as far as moving on to page 5 or so of a compromise and release, and I see this all the time, and I'm a little surprised, but why is it important, in your opinion, to make sure you properly list average weekly wages, TD payment history, permanent disability payment history, and medicals? Why is that significant on a compromise and release?
So the easiest answer to that is to avoid additional litigation, right?
Yeah.
Because the thing is signed and approved, it doesn't mean that uh, the parties can go back or cannot go back then and say, you know what, judge, there was error on
Yeah.
on this document, right? These numbers don't make any sense. So to try and avoid any additional or unnecessary litigation, it is always good to have the correct numbers there. Or
Hmm.
if you don't, then you contract and specifically say there that we dispute these numbers, but we're resolving them as a part of the CNR. We've all been there. I mean,
Sure.
you're going to be a few dollars here, a few dollars there. Nobody can really agree. Fine, then we'll agree to disagree, but we're still settling this case, right?
Yeah.
Why it's a
Yeah.
CNR. I mean, with the CNR, the
Yeah.
parties are given a lot of leeway and latitude to come up with creative solutions to resolve all manner of dispute, right? So if you don't have an agreement on the AWW, the earnings, whatever,
Yeah.
just say so, and but say you're still resolving. Perfectly acceptable. Better than leaving it blank, right? I always like to put something there. And same thing with the temporary disability benefits and permanent disability benefits. One thing that it's good to have the correct numbers there is you can kind of avoid arguments of missing payments
Oh, yeah.
or if EDD, we'll talk about liens later, but if EDD comes back, right? Sometimes they'll look at what you have written here on page 5 as a basis to see if there was any duplication. So you
Right.
want to make sure to make this as clear as possible, and most definitely for page 5 under that permanent disability paid, the biggest practice tip I can give to new and seasoned attorneys: make sure
Hmm.
that number on the bottom of page 5 is correct and you have the
Hmm.
dates, because again, when you move along to page 6, that number has to match that second line for permanent disability advances and the through date, right?
Yeah.
Because then if
Yeah.
you're going to try and assert a credit for ongoing advances, if those numbers don't line up, then you're going to have a hard time getting that back. I personally know that a lot of the Bay Area AAs would fight you on that. You know, it's not one of those things where you can just say "A clerical error." They'll try and spin it as if there was some kind of agreement that you're waiving advances or whatever, when that was not contemplated by the parties, right? So just save yourself some trouble.
Yeah, that's really important. That goes back into touching base with your client. Claims and defense should be on the same page, and that includes, hey, how much has been paid to date in PD? When you're on point with that and you properly list that on page 5 and page 6, then when the order proving compromise and release comes in, everyone's going to be on the same page. The client's going to know what to deduct because that PD has been ongoing through the date of the order proving CNR. That applicant's going to know that, hey, they're going to get deducted PDAs that they've gotten after they executed the compromise and release through the date of the OACR. AA is going to be on the same page. We're going to be on the same page. You lose nothing by being upfront and accurate, listing that stuff down properly. And also, practice tip: go ahead and put on page 5 and page 6 with regards to benefits paid, all of them subject to proof, jurisdiction reserved. Subject to proof basically means, hey, this is all subject to what the benefit printout reflects. AAs love that because they know that we're not trying to pull a fast one. And jurisdiction reserved. Hey, if there was something in error, then guess what? Post order approving CNR, we can hopefully go back to the WCAB to have any type of issues resolved. So that stuff does come in handy. Now, JP, moving on to page some of the lien language. What's your opinion with liens and properly addressing them into the compromise and release?
A good practice tip when drafting this is always, always, always check EAMS.
Always.
Always check EAMS. Always check EAMS, right? Um, there may not have been a lien yesterday, but there could be a lien today. In fact, you could be settling this case today and there could be a lien tomorrow, right? We all know medical treatment liens, statute of limitations on that. They could come at any time after the last treatment. So, as if a claim is accepted, the applicant could be treating right in the middle of post CNR being signed through OACR, right? So arguably there could be liens after, but why not just save yourself some trouble, check EAMS while you're drafting, and of course, note that who will be responsible for those. In particular, there's also what I like to call hidden liens,
Mm-hmm.
which is like usually the statutory liens such as EDD
Oh yeah.
and Medi-Cal. They have a legal basis for a lien without necessarily having to file an actual lien at the WCAB. So another practice tip there is for EDD, just give them a call or give
Yeah.
them an email when feasible. Um, we all know that everybody has the story of like them trying to reach EDD and just have not been
Yeah.
able to get anybody. So you do what you can. You do what you can. Recently, I've had to file a status conference, right, to get EDD to come to the table. But at least you may have a little bit of a delay there, but at least you get it done versus not. But I'll only do that if I know that they've got EDD, right? Normally, AA will be aware, right? But for the most part, check EAMS, give them a call, and that'll take care of that right there for you.
Yeah. So the huge practice tip which JP said was check EAMS. That's going to list lien claimants. But for our listeners who really want to get the biggest advantage, I am a huge proponent of, and I only preach this because I follow this, is check with EDD on every settled case. Yes, I know it's not easy getting a hold of your EDD rep. Guess what? Bradford and Barthel has offices at every WCAB throughout the state. So just because you're in claims land, not knowing who to contact at EDD, that makes sense. You're not supposed to know every single EDD rep in the state. There's hundreds, but someone at our firm will know someone who to contact at your particular WCAB to get that information. It may be so simple as, hey, EDD confirmed they haven't paid based on the injury. That's fine. Put that language into the compromise and release. Confirm with EDD they have not paid any benefits. Because if they're not on the address record, they can still easily get paid benefits. The main reason why I'm a huge proponent of checking with EDD is because oftentimes they're not on the address record, okay? But they've somehow along the way sent some type of notice to someone in claims that could get buried. And guess what? If they've sent notice to claims and if you settle behind their back, EDD is not going to simply take the day off and say, "Fine, we thought you knew. Have a good day." No, you don't want to have a situation where you pay in the front of their lien and then later, after the applicant's case is done, there's no money left out of applicant settlement. You don't want EDD to come back and say, "Hey, defendant, you knew about our lien. You settled in the face of our lien. You now owe us X amount of money." There's no worse feeling than that. We hopefully want to avoid that. So, getting back to basics here, check with EDD. You never lose anything by doing so. You only gain the peace of knowing that you're good to go. Now, page 7 of the compromise and release is just, I always say, hey, state who the doctor is you're settling the case on, and just say, hey, we're settling based on Dr. X's report, dated blank, which rates to blank PD. You want to spoon feed the judge all the information without having to get them to look through the medicals on their own. You want to make sure that if it's adequate, hey, make the judge's life easier, spell that out into the compromise and release. Any additional information that you recommend, JP, before we get to the addenda?
Uh, Page 7, I
Yeah.
would say, is deceptively
Uh,
simple, but one of the most important parts of your CNR, right?
yeah.
Starting on paragraph 9 there, where you do all these initials, that literally is resolving what other issues you are resolving as a part of this CNR.
Fair.
If you forget to initial future medical treatment, then what you thought was a CNR is not your classic CNR. Future medical treatment remains open. So you
Right.
got to make sure you have all of these things initialed uh, as appropriate, right? If your
Yeah.
jurisdiction will allow it, just top to bottom,
Yeah.
right? But
Yeah. Yeah.
more often than not, they will not. So be judicious about that, right? Normally, we don't really dispute jurisdiction. Are we really disputing employment? Probably not, but
Yeah.
statute of limitations, probably not, but everything else, probably yes,
Yeah.
right? Future medical for sure. Apportionment 100%,
Yeah.
TD, earnings, everything. So, and as you were saying, I do like to put in the type in space there the basis, which doctor, even the PD, if applicable.
Yeah.
Under that other, I usually like to again explicitly put in items like out of pocket expenses, mileage. Um, we know that applicants are supposed to periodically request mileage reimbursement, but in practice, sometimes they just don't.
Right.
And so, but you want to make sure all of that is addressed at the time of the CNR.
Right. No, great points, JP. Page 7, I shamelessly initial every line that I can. SJDB, post, I think, 2017, dates of it. The judges won't allow you to even initial that, but why not initial everything? If you're paying to buy out a claim, then you might as well get your money's worth, right? Initial everything. That's definitely a practice tip that we should all be striving for. Now, as far as the addendum go, I think like the other topics, we could have an episode or two alone on just the specific addenda or addendum. Which one is? I think it's addenda when you're talking plural, I believe. As far as addenda go, I do like to have specific addenda. If it's just a normal accepted case, I'll have an addenda reflecting, hey, the applicant agrees they're not on Medicare, they're not on social, they're not eligible. Have them sign off. If they're not on any of those, AAs won't object. You get to have peace of mind and you get to close that out. I do have an additional addenda that I like to put in that, hey, this resolves all issues regarding retro TD, mileage, out of pocket expenses, penalties, interest, etc. If there's an MSA, then you're probably going to want to have your own specific MSA addenda. Feel free to reach out to one of your defense attorneys here at Bradford and Barthel. We do have copies of those that we recommend, or at least I recommend. JP, what are your thoughts about addendum, including addenda, including for MSAs and even Thomas findings for denied cases?
I do like addenda because just the format of the CNR itself. There's limited space, so we want to make sure that we're not trying to jam a bunch of legal language in there. So it's like at 1 point font, you need a microscope to see what's going on. So put it in addenda as long as it's not something that's barred. Again, like we talked about, those body parts are so important, right? You can't refer to body parts in addenda. That specifically said, it specifically says that on paragraph number 3 on page 5 of the CNR, right? Saying that only those body parts are resolved. No other body parts in any other part of the CNR are going to be considered, right? So, make sure you have the right body parts. But for addenda, yes, penalties with respect to Social Security, 100%. For Thomas finding, I prefer using a whole separate
Sure.
addenda for and outlining the basis why the claim is denied
Oh, yeah.
as justification for that Thomas finding. Technically, if you look at that case and Beltran, it actually does indicate that there is articulated reasons for the denial, right? So having that outlined in an addenda is helpful. And I think a judge is more likely to approve that type of CNR if it's listed there. And it doesn't have to be a novel, right? Just
Uh-huh.
the reasons for, again, like what we talked about earlier with the hostile work environment, a factual dispute on the
Yeah.
mechanism of injury, no medical evidence or no contemporaneous medical evidence pre-injury, right, or pre-termination, right, to substantiate the injury, or any other basis used to deny the claim is appropriate for that addenda. If you had an MSA, I like to put in the terms and conditions as an addenda because normally those terms and conditions outline who gets paid what, right? So yes, I would put that in page
Mm.
6 as well. However, normally when I do that, it's to, for example, if you're doing professional administration, I'd put, dollar amount payable to, for example,
Yeah.
Amitros for
Yeah.
the MSA seed per, and then you put the addendum where they put the full terms and conditions. Similarly to that, if there's going to be an annuity, right, some
Oh, yeah.
dollar value from your settlement is going to be paid to the annuity company to fund those periodic payments for the
Mhm.
MSA. Well, you're not going to be able to fit all of that on paragraph 7 in page 6 of your CNR. So again, that would come into the terms and conditions. And your MSA vendor should hopefully be providing you that, because that really does outline who gets paid what and for which portion of this MSA, whether it be the seed, periodic payments, et cetera, right? And some judges want the copy of the MSA and the CMS approval too. I'll stick that on as an addenda
Sure.
as well.
And I know you mentioned the Beltron as far as that goes. That protects defendants against a voucher for denied cases. So great insight on that, JP. Also, one more practice tip. If you have a denied case that's settling with a Thomas addendum, go ahead and put that and request a Thomas order approving compromise and release. Go ahead and ask the judge to, hey, judge, please respectfully check the box off issuing that this is a Thomas finding. Why? Because if you have a lien claimant later that comes back and says, hey, you owe me X amount of dollars for some treatment that I did for a body part, you can thereafter say, hey, guess what, lien claimant? Not only do I have language reflecting that it's a Thomas denial, but the order approving CNR reflects that. So that's going to help you really reduce or negate a lien claimant's right post order approving CNR. JP, you've been phenomenal. Thank you for coming back on Comp Corner. We hope to have you back on for a third installment and segment as a third-time attorney, hopefully soon as well.
Sure, I'd love to.
That's a wrap on today's CE episode of Comp Corner. A big thank you to JP Torres for joining us and sharing his insight on navigating workers' compensation settlements. Check the show notes for sending your Comp Corner questions. Thank yous all around to Amir and Tammy for producing this episode. Thanks for listening. I'm your host, Nasir F. Adil. We'll see you next time on Comp Corner.